Good afternoon, everybody. I'm Julie Bond. We only do SR&ED, and about 30% of our cases are in this field, so we have a lot of experience. Today I'm going to be talking about contract analysis, some of the experiences we've seen in the FTCAS process, and then some tips. So, there's been talk about this already as far as what type of MPCs are being targeted. So just to clarify, we do see doctors that are basically staff doctors. They work at a hospital, they receive a T4 from the hospital or the university. They also have an MPC on the side, and then they try to attribute their hospital R&D through the corporation. And CRA has definitely been trying to track down on these types of claims, and at our position at Bond is that CRA is correct, that if you're a staff doctor, you receive T4, you have an employment type of contract, that work is probably not related to your MPC. But there are doctors that are fundamentally different. They're like the other ones that have been described here. They're an MPC, they have a contract with a lot of boilerplate clauses related to academic responsibilities, lecturing and research, and a lot of the times these doctors don't even realize that their contract requires them or doesn't require them to do research. They consider their research entirely independent. They just happen to have a relationship with a hospital or university, and they consider themselves independent. And CRA seems to be targeting these type of MPCs as well, under the guise of the previous notion is that they're employees when they're clearly not. So what we see CRA is doing is they're scrutinizing every single line of these contracts. Many of these contracts state that the doctor is an independent contractor and not an employee, but somehow CRA still comes to the conclusion that they're employees, so we have some difficulty with those types of interpretations. We see them, CRA, assessing these contracts in every way possible that allows them to deny the claim. Sometimes, not in all cases, but the times where they look at these contracts, and even if there's other evidence that the doctor is working independently and does not work for the institution directly and is not an employee, sometimes CRA still takes the position that they are an employee when the evidence would suggest otherwise. What's concerning is we've seen CRA dismissing verbal testimony and solely going based on these boilerplate contracts. So we've seen doctors who literally say, no, this is my independent project, and yes, I'm affiliated with that institution, but they are not directing this project. But CRA may reject those verbal testimonies. Sometimes we've even seen it in the CRA review. Doctor said this, but we rely on the contract. We also see the review process taking a very long time. From 6 months to a year in audit, and as we all know, that's exceptional. An audit shouldn't take long. Like after CRA has all the evidence that they need, they should be able to make a decision within a few weeks. 6 months to a year is exceptional, and we have a few cases that are in that ballpark, and that's very concerning. CRA should know their policy when they're going into an audit and should be able to make a decision and write it down and give the claimant the opportunity to file notice of objection. Some of the things that we've seen is CRA going out and looking in the public domain, and let's say they find a professional profile of a doctor who is associated as a part-time lecturer or something with a university. They'll infer employment relationship even though they don't have one. And then they will find public university or hospital policy that's available online, and they may assume that it applies to the doctor, and that would come out without any discussion or questions to the doctor. It would just become the assumptions on the denial. So you have to be careful of those things that you may see. We do see CRA expecting rebuttals, and we have seen CRA giving us the benefit of, if you intend to rebut this position, please provide the following documents. And that's actually very helpful, because then we can say, okay, there are some additional documents that they would like to see. Of course, we have seen situations where CRA is asking for documents that don't exist to prove a point of something that doesn't exist. So it's kind of can be difficult. How can you prove that you're not employed by someone? You don't have a contract to show that you're not employed by someone. The absence of the contract proves that you're not employed. One of the workarounds to that is to show the personal tax return of the doctor. If the personal tax return from the doctor does not show that they have employment income from a hospital or university, we take the position that they're not employed there. So there are other ways around CRA's positions where they're trying to work out where this doctor and their MPC is related to the contracts and their employment income. When it comes to IP, we see this as a bit of a red herring, because IP is usually related to two entities, both of which can claim for the shred. So in this case, we all know that hospitals and universities are non-for-profit. Since they can't claim shred anyway, there's never going to be a double-dipping issue. So we think this is a little bit of a red herring when it comes to talking about IP. But in most cases, the doctor does have the right to exploit anyway, as we've seen, or as we heard from Dave Sabina earlier. And we all know that in this industry, no public publication is going to say something like, we give credit to the MPC. We give credit obviously to a person who did research, but that person was employed by their professional corporation. Their T4 is from their professional corporation, so the professional corporation should be able to make this claim, even though the person is able to put their name on any publication. Next, I'm just going to go into the FTCAS process, First-Time Claimant Advisory Service. For medical cases, we have seen many times where an FTCAS will go quite reasonable until the end, and then we hear concepts or phrases very much like, by the way, you have received your FTCAS, but you should be notified you're not eligible. Do not claim again. If you do claim again, we will deny you. I just want to advise that in many cases, the results are the opposite. We've had many clients who kind of ignore this, kind of suggestion that they'll be denied in the next round, and then their next claim goes in and it actually is approved. It is something to be concerned about, and I think it's something that we should raise as stakeholders to CRA, is why are these messages going out to FTCAS recipients about not being eligible and do not claim again? I think it's a little bit of a concern. As far as some of the tips I'd like to give, CRA is looking for proof that the doctor is working on behalf of an MPC and not at the direction of another institution. So as long as the doctor is an independent subcontractor and is not an employee of a hospital, then that should be fine. And a lot of these contracts already say that. So if you're in this situation, you should really remind or point out to CRA that, yes, the contract does say independent subcontractor, and many of them actually do. Many of the contracts specifically say, and is not an employee. So I think that's very important to show to CRA that there's no employment relationship, and then the corporation has the right to employ its doctor, and then it has incurred the expense. I think there's another interesting concept here is to call these claims potentially as an SR&ED joint venture between a non-claiming entity and a claiming entity, and then each entity can claim its own expenses. Of course, the hospital or university cannot claim its own expenses, and usually it has not incurred any expenses anyway. And then the MPC in joint venture can also claim its part of its expenditures, and they always do because they pay the T4 salaries to the doctors who are doing the research. So this is also one way of presenting these type of projects to CRA as a joint venture. I think it's a very good tip is to start showing these contracts directly from the hospital to the MPC, so there can be no doubt. What we've heard is from some of the doctors to say, you know, the hospitals have their contracts and they don't want to change them, but they don't really do any benefit for anybody. They're old contracts, and they didn't anticipate any tax implications from these contracts. But ideally, if you can have, if the doctor does have an MPC, just go back to the hospital and renegotiate that contract and say, listen, can you please hire my MPC as opposed to my name personally, so that there's less confusion with CRA. Of course, R&D time has to be documented properly so that it doesn't overlap with other professional obligations. So if the doctor has clinic time or patient time or any academic responsibilities, the SR&ED time should be clearly spelled out in their calendar. And even if it's evenings and weekends where appropriate, that should be fine. That way, those calendars can be cross-referenced with any corporate contract that says how many hours or how many weeks of time or what percentage of time should be research or other types of activities, and make sure the whole thing makes sense so that the R&D time is carved out properly. If you're in one of these situations, one of the things you can do is ask for a PCPR next time around, so that you can get some more guidance at policy. It does sound like there's a lack of actual directions. I don't know how much guidance you will get from the PCPR, but it's perhaps a good tip to go ahead and engage directly with the government before you put your next claim in, to see what position that they're taking on these cases. As I said, have the contract directly with the MPC. Grants should be in the name of the corporation and should be funded directly to the MPC. We should deduct any grants received by the corporation for the SR&ED claim. I think that's obvious. And you can provide the personal tax return to CRA to prove that the doctor is not receiving employment T4 income from any of the contracting hospitals or universities, and this would dissolve any argument with regards to employment. Now, when it comes to this issue, it's a little alarming to me to hear that there are notices of objection out there that are lasting so long, 1 year, 2 years, 3 years, 4 years. As a reminder, once you file your notice of objection, if CRA is not in the position to handle your notice of objection, go straight to tax court. Within 90 days, you can file with the Tax Court of Canada, and then they will be forced to decide whether they want to proceed. You'll take your case straight to the judge, and then you can present your case that the work was done directly by the MPC, and perhaps get a judgment directly from the judge. And at that point, CRA may also make some type of settlement with you, since they don't have their policy straight anyway. But if you are in that limbo, just to remind you on the deadlines, you have to file your notice of objection within 90 days, but if you don't, you still get another 365 days. So if any of your claimants are in that position, they should file a notice of objection, and then within 90 days of receiving that notice of objection, you can go straight and request a date with the Tax Court of Canada, and then your case will be effectively removed from the notice of objection and appealed forward and go straight to the justice system. At which point you won't have to wait any more lengthy time while CRA is trying to decide on their policy on this issue. And as a reminder, when your case does go to tax court, the balance of probabilities is the judge's bar, right? So the whatever CRA believes is their interpretation beyond a reasonable doubt, or whatever term that they would like to use, any policy that they have that they're relying on, or what policy they don't have, it really won't matter to the judge. The judge will look at the Income Tax Act, will interpret it as so, and will also use the bar as on the balance of probabilities that the work was done by the MPC. So those are the kind of the tips that I have, and anybody has any other questions for me at any time, feel free to contact me directly. But again, these are types of experience that we've had with CRA for the last few years.
Thank you very much, Julie. It's Earl Viner. Had some technical issues earlier, but now I'm here. I'll make a very brief couple of comments that applies to this, but a lot of the issues that are raised here are significant issues that arise in many contexts, not just with respect to medical doctors. One is CRA constantly confusing the idea of the right to exploit, that you need to have ownership of the IP. And even before the IT was mothballed and then canceled, they always seem to be confused by it, and I've seen it it's getting worse over time, is the bottom line from my perspective, that CRA still confuses the issue, and they're always looking at who owns the IP, which is not the correct question, so you have to constantly correct them on that. The other issue I just want to comment quickly again that's with this, yes, the contracts and the money coming in is fairly general. And if you go back far enough, again, it's the IRAP days, where as soon as a company got an IRAP claim, 100% of the IRAP claim was applied against the R&D, even though in the IRAP claims, it actually had who the money related to and how they got the funds they got. Eventually, CRA came on side to allow the amount related to the individuals being the amount that reduces the claim. So I think it's still got a ways to go on the medical side. With that in mind and trying to stay on schedule, there is some time for a few questions. So if anyone has any questions, please let me know before we go on to the next topic of new CRA directives.
Just one comment from me, if I could, before we move on.
Sure. Who's this?
This is Elizabeth Lance from the Ingenuity Group.
Elizabeth.
Hi. So Julie brought up some wonderful points in her presentation, especially about getting a feel for what's going to happen from the Canada Revenue Agency before you file your return. There have been a couple of changes to the services that are offered to taxpayers at the beginning, and the PCPR, as far as I know, has been retired. And it's now being replaced with the pre-claim consultation, pre-claim review, both of which haven't been around long enough to really establish how useful they are from the experiences that we've had so far. But I wanted to emphasize, especially if anyone from the CRA happens to be listening today, the value of the PCPR as it previously existed. And Julie is absolutely spot on that that was a valuable service that helped provide guidance before people went into submitting a claim with or without the assistance of an SR&ED consultant. So if people are looking for guidance in advance, they should check the services and tools that are available on the website. There are those two that are listed right now, pre-claim consultation and the pre-claim review.
Thank you.